New Hampshire has a lease termination framework that balances its independent spirit with meaningful tenant protections. The governing law is found in New Hampshire Revised Statutes, Chapter 540, which covers actions against tenants, along with Chapter 540A, which addresses landlord-tenant obligations. Together, these statutes create a clear process that landlords must follow carefully. Let's start with no-cause termination. For month-to-month tenancies, New Hampshire requires the landlord to provide at least 30 days written notice before the termination date. The notice must be a proper notice to quit, and it must comply with specific formatting and content requirements under Chapter 540. The notice must identify the premises, state the reason for the termination, or state that no reason is required for a periodic tenancy, and specify the date the tenant must vacate. Here's an important nuance. New Hampshire requires the notice to quit to be delivered by specific methods. Acceptable delivery includes handing it directly to the tenant, leaving it at the tenant's last and usual place of abode, or sending it by certified or registered mail. Improper delivery is one of the most common reasons eviction cases get dismissed in New Hampshire, so documentation of how and when the notice was delivered is critical. For fixed-term leases, the lease expires at the end of the agreed term. New Hampshire does not require additional notice to terminate a fixed-term lease at its natural expiration unless the lease says otherwise. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to an at-will or month-to-month arrangement subject to the 30-day notice requirement. For week-to-week tenancies, New Hampshire requires 7 days' notice from either party. Now let's cover termination for cause. For non-payment of rent, New Hampshire requires the landlord to provide a 14-day demand for rent before filing for eviction. Under Section 540.3, the landlord must deliver a written demand giving the tenant 14 days to pay the rent owed. If the tenant pays the full amount within 14 days, the demand is satisfied and the tenancy continues. If the tenant doesn't pay, the landlord can proceed with filing a landlord-tenant writ in district court. New Hampshire's 14-day non-payment window is longer than many states and reflects the state's emphasis on giving tenants adequate time to come up with the funds before losing their housing. However, the clock starts when the demand is properly served, not when rent was originally due, so landlords need to act promptly to avoid unnecessary delays. Here's something important about New Hampshire's non-payment process. The state has a right of redemption that extends well into the eviction proceedings. Under Section 549, the tenant can pay the full amount owed, including rent, interest, court costs, and attorney's fees, at any time before the writ of possession is actually issued. If the tenant makes this payment, the case is dismissed and the tenancy continues. However, this right of redemption can only be exercised 3 times in any 12-month period. After the third use, the tenant loses the redemption right for the remainder of the 12-month period. This provision prevents chronic non-payment while still giving tenants a meaningful safety net. For lease violations other than non-payment, New Hampshire uses a 30-day notice to quit framework for most situations. The landlord must provide written notice identifying the violation and specifying the date the tenant must vacate. For curable violations, the tenant should be given a reasonable opportunity to correct the problem within the notice period, though the statute doesn't mandate a specific cure period for most violations, the way some states do. New Hampshire does have specific statutory grounds for eviction that create shortened timelines in certain situations. Under Section 540.2, the recognized grounds include non-payment of rent, substantial damage to the premises, behavior that constitutes a serious nuisance, violation of a material term of the lease, and other specified circumstances. For conduct that constitutes a significant nuisance, including excessive noise, threatening behavior toward other tenants, and activity that substantially interferes with neighbors' quiet enjoyment, the landlord can issue a notice to quit and pursue eviction. New Hampshire courts evaluate nuisance claims based on the severity and frequency of the behavior, and a well-documented pattern of conduct carries more weight than an isolated incident. For criminal activity on the premises, New Hampshire provides expedited procedures. If a tenant or someone under the tenant's control is involved in drug-related criminal activity, the landlord can pursue eviction on an accelerated basis. Under Section 542, drug-related criminal activity is a specific ground for eviction, and courts in New Hampshire treat these cases with urgency. New Hampshire also has a specific provision addressing situations where the tenant creates a health or safety hazard. If the tenant's conduct or the condition of the premises, caused by the tenant, creates an immediate threat to health or safety, the landlord can seek emergency relief through the court. This may include a request for a temporary order requiring the tenant to vacate while the situation is addressed. The eviction process in New Hampshire goes through the Circuit Court, District Division. The landlord files a landlord-tenant writ along with the required notice to quit. The court schedules a hearing, typically within 2 to 4 weeks of filing. New Hampshire's process requires the landlord to properly serve the writ on the tenant through an authorized method, personal service by a sheriff or certified mail. If the court rules in the landlord's favor, a writ of possession is issued. The tenant then has a period to vacate, typically a few days, before the sheriff carries out the physical eviction. The overall timeline from filing to removal is approximately 4 to 6 weeks for uncontested cases, though contested cases can take longer. New Hampshire courts allow tenants to raise several defenses in eviction proceedings. The most common defenses include improper notice, retaliatory eviction, the landlord's failure to maintain habitable conditions, and discrimination. If the tenant raises a valid habitability defense and can demonstrate that the property has unresolved defects that the landlord knew about, the court may deny the eviction or impose conditions on the judgment. On the tenant side, New Hampshire provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, as we covered in our New Hampshire habitability video, the tenant can provide notice and allow the landlord a reasonable time to make repairs. If the landlord doesn't act, the tenant can pursue remedies including lease termination. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. New Hampshire has a presence of military personnel particularly associated with the Portsmouth Naval Shipyard and installations in neighboring states, making this provision relevant to tenants in the state. New Hampshire enacted protections for victims of domestic violence, sexual assault, and stalking under RSA 540(2) and related provisions. A tenant who is a victim of these crimes can request that the landlord change the locks to exclude the perpetrator and can terminate the lease early by providing written notice along with qualifying documentation. The tenant must provide at least 30 days' notice and include documentation such as a valid protective order, a police report, or a statement from a qualified professional. The landlord cannot charge early termination fees or penalize the tenant for the early termination. New Hampshire also provides early termination rights for tenants who need to enter a care facility due to age or health conditions. The tenant must provide adequate written notice, along with documentation supporting the need for relocation. New Hampshire strictly prohibits self-help evictions. Under RSA 540-A:3, landlords cannot change locks, shut off utilities, remove doors or windows, remove the tenant's belongings, or take any action to force a tenant out. The penalties are significant. The tenant can recover actual damages or 3 months' rent, whichever is greater, plus attorney's fees. New Hampshire courts enforce this prohibition consistently, and a landlord who engages in self-help not only faces financial liability, but also risks undermining any legitimate eviction case they may have. One important aspect of New Hampshire law is the prohibition against retaliatory evictions. Under RSA 540-13-A, A landlord cannot terminate a tenancy or take other adverse action in retaliation for a tenant making a good faith complaint about habitability to a government agency, complaining to the landlord about conditions, or exercising any legal right. The protection lasts for 6 months after the tenant's protected activity, and any adverse action during that window creates a presumption of retaliation. New Hampshire also has specific rules regarding the handling of security deposits. The landlord must hold the deposit in a separate escrow account at a New Hampshire banking institution. The deposit must be returned within 30 days of the tenant vacating, along with an itemized list of any deductions. If the landlord fails to comply, they may forfeit the right to retain any portion of the deposit. Additionally, New Hampshire limits the security deposit to 1 month's rent or $100, whichever is greater, making it one of the states that caps the maximum deposit amount. One more practical consideration. New Hampshire's relatively small population and limited number of courts means that the landlord-tenant bar is tight-knit, and judges handling these cases tend to be experienced in the specific nuances of the state's law. This works in favor of landlords who follow the rules carefully and against those who try to cut corners. Having a local attorney who knows the specific judges and court practices in your jurisdiction can be a significant advantage. For the complete guide to New Hampshire lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.